Okay, welcome to today's webinar, which is perhaps on everyone's least favorite topic, complaints. I am Sharia Ali. I am the complaints director here at ACSLPA, and I can tell you that managing complaints is not my favorite either. The process is very impactful on people, and it can feel very intrusive on people's lives and practice. However, the flip side for me is that it's a privilege to manage complaints at an organization that really puts value and emphasis on trauma-informed and culturally safe practice and on being responsive and sensitive to everyone that has to interact with the complaints process. So the purpose of this webinar today is to demystify the complaints process and to provide some information that may be useful to anyone involved in the complaints process in any way. Before we get started, our usual housekeeping notes. You'll notice that your video and your mic are turned off. They're going to stay off for the duration of the presentation. It's just easier for us to manage on our end with this setup. If you encounter any technical difficulties, please let us know in the chat, or you can call the number in red on the screen, and an ACSLPA staff member will try to help you troubleshoot. And I think we'll also just put that number in the chat as well for folks. We're going to have to do questions a little bit differently today. I'm going to ask that you not ask questions in the chat and instead send them to the email on this slide. Given the very sensitive nature of complaints, we do have to keep information confidential. I know sometimes folks may have questions based on situations they're aware of. However, for this presentation specifically, we'd like to avoid seeing any information about specific situations or people in the chat. It would also make our lawyers very nervous if they thought I was out here trying to answer questions about legal concepts and procedures that may come up. I'm not a lawyer, as you can see from my RSLP designation on the slide, so I don't have the knowledge base to answer questions on the fly. So there isn't going to be a dedicated question period at the end of the webinar like we normally do. I will just keep talking until I run out of time or slides, whichever happens first. This is also my first time presenting a webinar in a long time, so I'm very out of practice, so keep your fingers crossed for me that I do well. So the lawyer who used to be the complaints director had this slide in her presentation, so I figured it was a good idea to have in mind. So quick disclaimers, the information in this presentation is not and shouldn't be considered legal advice. If you are ever in a situation where you need legal advice on the complaints process, we encourage you to seek your own legal counsel if you wish to do so. And this presentation is based on the law and legislation. It's current up to right now, but as we all know, laws are subject to change. So first off, you may be asking why we need a webinar on complaints. Is the college trying to tell its members something? After all, we know that the majority of members proceed throughout their careers without having a complaint being made against them. And when we look at the statistics, the number of complaints a college gets each year is actually relatively small. However, it is part of the college mandate to address concerns regarding unprofessional conduct from its members. And under the Health Professions Act, or the HPA, that's going to come up a lot in this presentation, ACSLPA is the place to go for anyone who has concerns about the conduct of an SLP or an audiologist. Now, part of the college addressing concerns is to take a proactive and universal approach to information sharing around complaints. So this helps to make sure that anyone involved has important information as they need and as they move through the complaints process. And yes, the number of complaints is very small, but ACSLPA members may actually be involved in complaints in different ways. So members may be a complainant, or they may be the investigated person, which refers to the person who the complaint is made against. Members may also be involved as witnesses, where they're required to provide information as part of the investigation of a complaint. And this is not uncommon. In the past, regulated members have been interviewed by investigators or had their records submitted as part of a complaint against another regulated member. An SLP or audiologist could also potentially be a witness in an investigation of a regulated member of another healthcare discipline, given the highly interdisciplinary settings we all work in. Importantly, a regulated member can also be a support person for a friend or a colleague as they manage their role in a complaint. Another scenario is a regulated member being the employer or the supervisor of one or more people who are involved in a complaint. We've definitely seen situations in the past where the complainant and the investigated person are on the same team, and that can, of course, affect other members of the team. So some roles in complaints are more involved than others, like if you're the complainant or if you're the investigated person. What I can say with certainty is that no matter your involvement, the process is complex. It can be incredibly stressful and difficult to manage. So what we like to accomplish today is to provide some clarity around some issues that come up most often. Our format is going to be different from our usual webinars today. I'm going to be jumping around a bunch of different questions or concepts that have come up a lot to do with complaints, and I'll be providing information on each. There's also going to be some poll questions to gauge member perspectives on some of the concepts. So this is going to be limited to choosing between a fact or a fiction option for each question. You don't have to type anything, only clicking is required. All I see is the aggregate response, not individual answers. However, if you feel like your participation today is just going to be listening, participation in the polls is optional. You'll soon see, though, the polls may help to break up the dryness of some of the content, so it might help to keep you awake and engaged if you participate in them. So we're going to test out our first poll question, and you should see that pop up on your screen there. So just let me know if you think it's fact or fiction that complaints to ACSLPA are increasing. So you can just pick which option you think is correct. If you don't want to participate in the polls, click on that X at the top right of the box and it'll disappear for you. And if you want to see the results, I'm looking at the chat. So I just have the chat open on the side of my screen, and right at the bottom you will see you'll see the results. So currently it's saying that 62% of attendees think that complaints to ACSLPA are increasing. And I can tell that lots of you have been very carefully keeping up with the ACSLPA annual plan and our result and the information we present on complaints, because this is a fact. Complaints to ACSLPA are increasing. So if we look at this graph, this shows a bit of the pre-pandemic, pandemic, and post-pandemic periods. The number of complaints received by ACSLPA each year is increasing. That line is going steadily up. And we are tracking to have similar numbers in 2025. So one thing to point out about these numbers, though, is that they actually represent a very small percentage of the membership. So if we look at 2023 and those 13 complaints that we received, that's actually representative of less than 1% of members having a complaint made against them. So the chances are low, but they aren't zero, and they are going up every year. The trend of increasing complaints is consistent with other SLP and audiology regulators and other healthcare regulators in Alberta and across Canada, and everyone is, tracking for this trend to continue. The statistics don't tell us why we're seeing this trend. I have some thoughts, put them on the slide. ACSLPA hasn't really been collecting any data to explain causation. But if the trend continues, it does make it more likely that regulated members may become involved in the complaints process in the future in all the different ways I talk about. So we have our second poll question, and you let me know if you think it's fact or fiction. This is something I get questions on a lot, that only clients can file complaints against regulated members. So I'm seeing results coming in, and it is so far as 100% fiction. So I will go to the answer. Wonderful, you all got that one right. That's fiction. Any person may file a complaint against about an SLP or audiologist, and this can include any of these people listed on the slide. Since I've been in the role, it's been a very mixed bag in terms of who we get complaints from. So I can't say there's any one group that's a primary source of complaints. Just a quick note here, that the complaints director under the Health Professions Act can also initiate complaints. This can happen when the complaints director has reasonable grounds to believe the conduct of a regulated member or a former regulated member constitutes unprofessional conduct. For example, this may occur when the complaints director is notified of regulated members returning to practice without reinstating their practice permit, or when members continue to practice past the expiration date of their practice permit without renewing. So a good tip on here is to avoid getting a call from the complaints director is to always make sure you have a valid practice permit before engaging in any professional activities. Importantly, this includes any non-direct client time, like file reviews or orientation. These types of activities also count as professional activities, which one should not engage in without holding a practice permit. So I thought this is a good place to outline for everyone what to expect when a complaint has been received by ACSLPA. So the complaints director will immediately review the complaint to get an understanding of what is alleged and what the concern is. So following on from that, we'll reach out to the complainant fairly quickly to confirm that we've received the complaint and to give a bit of procedural information, what happens in the short term. If needed, the complaints director may speak to the complainant directly to get more information to understand their concern better. The complaints director also then reaches out to the regulated member fairly quickly to notify them that a complaint has been filed against them. I'll also give more information, procedural information on what to expect. I'll let them know that they can respond to the complaint if they wish to do so. Now, a response isn't mandatory from a regulated member at this stage, but it is very helpful for decision making if I have the regulated member's perspective on what happened. So a really important point to note here is that regulated members will always be informed when a complaint has been filed against them. So we would never get a complaint, start looking into it, and then go to the regulated member months later and say, oh, well, we've been investigating you this whole time. That just simply cannot happen under the Health Professions Act. And we'll talk more about the rights of a regulated member later on. But one of the rights important to know is that members have the right to know the allegations against them. So after receiving a complaint and contacting the complainant and the regulated member, I then, as complaints director, review all the information I have so far on the complaint. So this can be what the complainant submitted, the response from the regulated member if they provided one, and then there's a very tight turnaround time for this review. And a decision on next steps in response to the complaint must be made and communicated to both parties within 30 days of receiving a complaint. So that might sound like a long time, but in my experience, the 30 days just flies by when you're trying to understand multiple perspectives and give your due diligence to the decision. So the possible actions that the complaints director may take are listed on this section of the slide. Most commonly, though, we'll see attempts at resolving complaints, dismissing when there's no evidence of unprofessional conduct, or referring to an investigation. And later on in the presentation, I will go over what happens after this initial 30-day period. And so this isn't a poll question. This is more for my information. See what member preferences might be. So I want you to sort of put yourself in the frame of if you were going to be contacted by the college to inform you, to notify you about a complaint, like what would you prefer? I know this comes down to preference. Some people like me would prefer an email so I can sort of process the information, have my interaction, or have my reaction to it, not on the phone with someone. Other people might say, you know, this is a very important conversation, needs to happen in person so that you're immediately available to provide information. So just want to survey the group. And I'm seeing that most people, 78% are leaning towards an email. So we'll just make a note of that on our end and kind of thank you for providing that information and your perspective. It might help guide our procedure in the future. But I'm seeing 80% of folks would prefer an email. So straight into another poll question. Let me know if you think this is a fact or a fiction. ACSLPA cannot accept anonymous complaints. So give it a couple of seconds here. I'm seeing most folks are saying this is a fact, 75%, now 80%. So you were all right again. So, most of our attendees were right again. So this is a fact. ACSLPA can only accept complaints if they include a name and a signature. And that comes straight out of the HPA, and I just screenshotted that section 54 sub 1 on there that says that a person who makes a complaint to the complaints director regarding a regulated member or former member must do so in writing and must sign the written complaint. So when I talked about notifying the regulated member earlier, it's important to know that this includes providing a copy of the complaint form and any other materials we received. So although we redact information like contact info, like phone numbers and addresses, the complainant's name will be shared with the person who has the complaint made against them. So we do recognize that the requirement to identify yourself can be a barrier to filling out a complaint. There are valid concerns about this for retribution or just creation of an uncomfortable environment situation. However, I hope you can see we do this in the practice of, in the spirit of fairness. People who have a complaint filed against them have a right to know the allegations against them so that they can adequately respond to them. Also, we're expecting a lot of accountability and transparency from investigated persons. And so we will also want to expect this of anyone who makes a complaint, that they're accountable for what they're alleging. So ACSLPA does have some mechanisms to manage privacy for all parties. It's our policy, as I mentioned, to redact contact information and documents that are shared between parties. Very early on in the intake process, we ask both parties, the complainant and the investigated person, to maintain confidentiality, and this includes not contacting one another about the complaint. We also make sure that communications between ACSLPA and the complainant and the investigated person are kept entirely separate. For example, we would never put both parties in the same email chain, even when we're sending the same document or information, and we never require both parties to be in the same room, virtually or in person, when we're gathering information. So we touch a bit on the rights of the regulated member, specifically to know the allegations against them. So I'm just going to detour a little bit. I think this is a good spot to go over regulated member rights, and these are all established in relevant legislation. So anyone who has a complaint filed against them has certain procedural fairness rights across any and all parts of the complaint process. So like I said, you have the right to know the allegation against you so that you can respond to them. So, responding is also a right that you have to respond to any allegations that are made against you and to give your perspective. We'll talk about hearings later. They can be a very scary process, but they are a right. Regulated members have a right to have their day in court and to be heard. You also have the right to an appeal. And related to those rights, hearing and appeal, you have the right to an unbiased decision maker for matters arising from your complaint. And you have the right to legal counsel at your own cost to assist you with your complaint. We'll talk more about legal counsels later. So we have another poll question. So fact or fiction? I get this question quite a bit. ACSLPA members are obligated to report concerns regarding the conduct of another SLP or audiologist. Just getting some time for the responses to come in. So far we've got most people saying this one is a fact. I won't keep you in suspense any longer. This one is a fact. Under the HPA, the Health Professions Act, regulated members must report concerns about the conduct of another regulated member to ACSLPA. So this can understandably be very difficult and uncomfortable. but I do have to remind members of their obligations under legislation to report concerning conduct so that the college can then do its job and protect the public. So note that reporting obligations applies to incompetent or unethical services as established in the minimum standards. So it's not anything to do about something that's just bothersome about a colleague, like, and that's outside of their scope of practice, like someone always using your parking space or how loud they type, anything like that. You don't have to inform a regulated member or talk to them about it before you submit a complaint. You can address the concerns with the regulated member or their employer or both if you feel comfortable to do so. And this can sometimes lead to a resolution without the involvement of the college, but it's by no means necessary. Any potential complainant, whether you're a regulated member or a client, can contact the complaints director to discuss a concern. However, I just want to point out there are limitations on what outcomes can be expected with these conversations. Like, as complaints director, I can't give any indication that yes, a regulated member definitely engaged in unprofessional conduct based on one conversation with one side of the issue. There are also limits to how I can follow up if I don't formally receive a complaint. So it's fairly common for ACSLPA to be contacted by regulated members, employers, or members of the public who have concerns about the conduct of a regulated member. And they're sometimes unsure of who's the best staff member to speak to. So just want to touch on that briefly here. If you need to find out what exactly the minimum standards are for ACSLPA regulated members in a particular circumstance, for example, if you need to reflect on whether you're concerned that those standards weren't met, you need to talk to either the audiology advisor if you're an audiologist or the deputy registrar if you're an SLP. You may contact the complaints director to discuss a concern. Complaints director may direct you to the best source of information for guidance on minimum standards, i.e., refer you back to an advisor. Complaints director can also give more information on the complaints process itself. Quite frequently, though, and why I'm talking about this, what I've found is that folks contact either an advisor or a complaints director with a concern, and they're sort of looking for confirmation that their concern is a valid one. That is, that the regulated member in question definitely engaged in some unprofessional conduct, and that a complaint should be lodged, and that the regulated member will be sanctioned. However, ACSLPA staff, as I said, can't make determinations about whether a regulated member's conduct was unprofessional based on a conversation with one party only. We can say what the minimum standards are, but we cannot say if someone has breached them without engaging in the proper process for receiving and managing complaints as described in the Health Professions Act. So what I would say, best course of action, if you have a concern about potential breaches of the minimum standards, submit a complaint to the college. Think of a complaint as a way to flag something to the college's attention for looking into, rather than it's submitting, proven unprofessional conduct to the college. It's the college's job to do the proving, but we do need concerns to come forward so that we can look into things. And the college, of course, trusts its members to know what the minimum standards are and to use the obligation of reporting a concern responsibly. I want to briefly touch on as well, employers also have a duty to report. So under the HPA, if the employment of a regulated member is terminated or suspended because of unprofessional conduct, the employer must give notice of the conduct to the complaints director. And this also applies if a regulated member resigns from their employment, so they weren't terminated or suspended. If the employer is of the opinion that unprofessional conduct occurred, prior to the resignation, then they do also need to bring this to the attention of the complaints director. So we have another poll question here. I think I sort of answered it already, but fact or fiction? A complaint means that a regulated member has engaged in unprofessional conduct. Seeing participants are very heavily leaning to this being fiction so far. and now we've got 5% saying fact and 95% saying fiction. And this what is fiction. A complaint means that the conduct is alleged. So at the time of receipt of a complaint, the conduct of a regulated member is alleged only. And we keep this in mind as we work through the process. So we try to ensure that we have a fair, transparent, and efficient process following on from the receipt of allegations. Each matter gets our due diligence based on the facts of the matter so that we can come to reasonable decisions. So it's important to note that not all alleged conduct in a complaint can be deemed unprofessional or will rise to the threshold of unprofessional conduct. So we have another poll question. Having a complaint made against them means a regulated member will have their practice permit revoked or that they must stop practicing. Again, seeing folks leaning heavily towards this one being fiction. Just give it a couple more seconds. Okay, so we've got 100% saying this is fiction, and that is right. However, the reason I'm bringing it up is because I do notice that this is perhaps a major area for misunderstanding for both complainants and investigated persons. Complainants can sometimes assume or expect that lodging a complaint will lead to the regulated member's practice permit being canceled. And I know regulated members may also think that it's sort of a foregone conclusion to having a complaint made against them is that their practice permit is going to be canceled. And this is just not true, as we'll see. Another outcome where I see a lot of misunderstandings is that all complaint matters go to a hearing. So I want to spend some time first just outlining the complaints process, including potential outcomes. So naturally, the process starts when we receive a complaint. And once we receive a complaint, as I said, complaints director has 30 days to decide on the action to be taken. So the options typically are to dismiss the complaint, to resolve the complaint by a resolution agreement, or refer the complaint to an investigation. So it's important to note that when we refer a complaint to an investigation, that doesn't mean that there's been a finding of unprofessional conduct. It means simply that we need more information regarding the complaint matter to then make a decision. So just because a complaint wasn't dismissed or resolved after that initial 30-day period does not mean that referral to investigation is evidence in and of itself that unprofessional conduct occurred. So based on the investigation information, the complaint, again, it can be dismissed or resolved through a hearing, resolved through resolution agreement, or it can go to hearing. So I'm going to go off script a little bit because I forgot to put this in my initial script, but something that comes up a little bit is concern that being a witness in an investigation of another regulated member can mean that your conduct is, coming under scrutiny, or what you've done in the situation will be scrutinized. I know that can be a fear that being interviewed or having documentation submitted as part of an investigation might mean that a witness's conduct will come under review, looking for unprofessional conduct on their part. Please note that that is not the case. When we ask an investigator to complete an investigation, we give them a very specific scope. So they don't have a blank check to go look into everything and everyone leading up to the conduct in the complaint. For example, we will say, please look into this specific person's assessment of clients A and B during the time period March to September 2025, and they have to stay within that scope. ACSLPA generally cannot open new lines of investigation outside of what and who is detailed in the complaint. However, I must say though, if something really significant comes to light, like sexual abuse or sexual misconduct, then of course we will take action. Generally speaking, though, if you are asked to be interviewed or your documents are submitted as part of a complaint for another regulated member, this does not mean that you yourself are under investigation or that your conduct is being scrutinized. It means that you have information that can help with the decision-making regarding the conduct of the regulated member who had the complaint made against them. So let's go back to our chart and note that after the first two stages, receipt of the complaint and investigation, there are these two off-ramps, I'm calling them. So dismissal or resolution. So dismissals occur when there's no evidence of unprofessional conduct on the part of the investigated person. Dismissals might also occur if the complaint is deemed trivial or vexatious. Resolution happens when the complainant and the regulated member both agree to resolve the complaint. Here, typically what happens is ACSLPA develops a resolution agreement and we negotiate the terms with the regulated member. So typically the regulated member will agree that certain conduct occurred on their part and that sanctions will be put forth to which they're going to comply. And I'll talk more about potential sanctions on the next slide. So if these off-ramps aren't taken after an investigation, only then will the matter proceed to your hearing. So you can see that not all complaints are going to proceed to your hearing. It's not an automatic outcome by any means. And a hearing resembles what we see on TV. So there are different parties. Information is presented to a decision maker, in this case, the hearing tribunal, who will then make a decision on findings of unprofessional conduct and decide on sanctions. So really importantly, a complaint is not off the books until there's compliance of the complaint. So this is where the regulated member complies with the sanctions or penalties that are put into place, and they complete the mandated activities by the deadlines identified. So it's important to note that throughout the proceedings, unless informed otherwise, an investigated person's practice permit remains intact and valid. They can continue working. In extremely rare circumstances, an interim condition suspending a practice permit can be applied at any point in the process. Like I said, this is an extremely rare situation. It's used only for very serious conduct, for example, sexual abuse or sexual misconduct or patient harm or theft from a patient. So here are some of the penalties or sanctions that can be applied as part of a resolution agreement or resulting from a hearing. So sanctions serve different purposes. Also, a caution or a reprimand sort of confirms the conduct was unprofessional, and it also acts as a deterrent to the regulated member. Other sanctions are related to protection of the public, like requiring someone to practice under conditions or to provide proof of capacity, or requiring participation in counseling or treatment. Other sanctions are rehabilitative, like coursework or doing an essay or coming up with a learning plan. Other sanctions like fines are punitive, but they also have an indirect deterrent and public protection effect. So penalties are individualized and they're fact-specific to each complaint. So when we're thinking about penalties in complaints, we think about proportionality, restraint, and enabling rehabilitation. Those are priority concerns. So while sanctions often have a punitive effect, like they can feel like punishment, punishment of a regulated member is not a standalone motivation. As complaints director, I don't just throw all of these sanctions on a resolution agreement just because they're available to me. I looked at what's going to be impactful in terms of public protection. So if we go back to the original fact or fiction question, cancellation of a practice permit is used only when the unprofessional conduct that's found demonstrates that the regulated member is ungovernable or that their continued participation in the profession would create an unacceptable risk to the public. So cancellation must be precipitated by very serious conduct and risk, and so it is not a foregone conclusion. I appreciate that this is where a lot of people's minds go once they hear about a complaint, and in that panic, they're going to lose their practice permit. But please note that cancellations of practice permits are actually pretty rare in Alberta. They're rare for ACSLPA, rare for other colleges in Alberta, and also across Canada. So we're going to go to Something else that I know can be really challenging for regulated members, and that's a publication of their disciplinary findings. So like with practice permit cancellations or referrals to hearing, publication of disciplinary findings is not an automatic conclusion in the complaints process. However, all hearing tribunal decisions are published. So if a matter does go to hearing, then that decision will be made public. But we do have some flexibility in the publication of resolution agreements. And the decision to publish resolution agreement findings is made on a case-by-case basis after careful consideration of the conduct of a regulated member and factors surrounding the complaint. When ACSLPA does include publication as part of a resolution agreement, this decision must be reasonable and appropriate to the facts of the complaint. So again, not all of them are published. It's important to note that a regulated member will always be informed if their disciplinary findings will be published. If publication is going to be part of a resolution agreement, remember this is an agreement. So the regulated member would have to agree to the publication terms before the agreement can be executed. So some, but not all complaints decisions are published on the ACSLPA website. There's usually a publication time frame that's established, and once that time has ended, then the publication is removed from the website so they don't stay up there forever. Disciplinary findings are also published in the public register. And in some cases, hearing tribunals may also stipulate that practice permit conditions arising from sanctions also appear on the public register. And on the next slide, we'll see an example of what that looks like. So we know that publication of disciplinary findings represents one of the more difficult parts of the complaints process for regulated members. However, publication is important for a number of reasons. First, it can offer insight to all regulated members about potential areas of unprofessional conduct. It also promotes transparency of ACSLPA's regulatory functions by allowing members of the public to see what is expected and the potential outcomes of complaints. Publications also help the public make informed decisions about their choice of practitioner. And publication also provides insights to the government about what aspects of the HPA are working and what could be amended. So this is an example of what shows up on the publication, on the public register, when there are disciplinary findings and conditions. So this is what members of the public can see when they search for a practitioner in ACSLPA's public register. So the top piece is going to look the same for all of us. As I mentioned, when there are conditions, perhaps, for example, if the hearing tribunal as a sanction says that conditions be placed on the member's practice permit, then they will show up. There's a special conditions section of the public register for each member, and they'll be listed there. So for example, this is an example profile. If there's conduct requirements like costs or coursework or essay, that'll be stated right on there. Once these conditions are met, they're pulled off of there. So once the member pays the cost, or they submit their coursework, or they submit their essay, and it's found to be satisfactory, we will take down those conditions. And then there will also be a link to the disciplinary finding, which is a summary of the agreement or the tribunal's decision that folks can then click on and go to that relevant agreement or decision. So finally, another poll question. You let me know if you think it's fact or fiction. Complaints can take over a year to resolve. So seeing a bit more of a mixed bag with this one. Most people are saying it's fact, though. I'll just give it a couple more seconds. Okay, so 76% of attendees think this is a fact, and they are unfortunately correct. So while the complaints director initially has 30 days to make a decision on next steps, this is the only time where there is an explicit requirement regarding a timeline for a decision in the HPA. So that's the only time where they say a decision must be made within this specific time frame. So while we do aim to address and close complaints as quickly as possible, so we know open complaints can be a source of anxiety or stress for all involved. It's just not a nice thing to have hanging over your shoulder. However, we do have to apply our due diligence to all decisions because complaints are high impact decisions that can have serious implications for complainants and investigated persons. We're also accountable for our decisions through the appeals process. So we have to demonstrate reasonableness and that we apply the required levels of attention. So investigations take time. Multiple people have to be interviewed, documents have to be gathered, a report has to be written. Once investigation reports come back to ACSLPA, we have to take our time reviewing these very lengthy documents to make a decision on next steps. If we try to get a resolution agreement, again, that can take some time. We have to draft up the agreement and then we have to negotiate the terms with the investigated person before any agreement can be finalized. Hearings can take much longer. A hearing tribunal needs to be put together. There are many different administrative processes that need to be ticked off, completed before the actual hearing. So when a complaint goes to hearing, sometimes it can be over a year from the time of receipt of a complaint before we have the hearing tribunal's decision actually in our hands. Even after resolution or hearing, a complaint isn't considered closed until an investigation has demonstrated compliance with all the sanctions or penalties as per their agreement or decision. And if any decision is appealed, this again lengthens the process. The complaint matter stays open until the relevant decision-making body for an appeal process has handed down their decision. So another fact or fiction question, engaging legal counsel to manage a complaint will make the investigated person look guilty or is an admission of wrongdoing. So getting a lawyer involved or lawyering up will make you look guilty. And that's great. I'm seeing all responses so far saying this is fiction. So yes, it is fiction. And in fact, ACSLPA recommends getting legal counsel. This is not mandatory. If folks prefer not to engage legal counsel for any reason, the matter will proceed as usual, as directed in the Health Professions Act. It's important to note that engaging legal counsel will not result in any prejudgments on ACSLPA's part. We know the process is stressful and it's complex. It's also important to note here that ACSLPA actually cannot and does not act as a resource for legal advice to any parties involved in a complaint. So the investigated person would be best placed to engage their own legal counsel to support them through the complaint. And regulated members can consider contacting their professional liability insurer for assistance. So also just want to note here that actually ACSLPA decision makers, including myself as complaints director, hearing tribunal, and the complaint review committee, they all have independent legal counsel to help them navigate the process. From a personal perspective, like I said, I'm an SLP in this role, and having access to legal counsel is very helpful in making sure I understand the nuances of complaints and I get advice whenever I need it. So I can't mandate anyone as complaints director to get legal counsel when facing a complaint, but I will say that if I was ever in the position of being an investigated person, first thing I would do is engage legal counsel, just knowing what I know now about how complex and stressful the process would be. So we have another fact or fiction. Complaint matters can't proceed without the engagement of the investigated person. So if they just didn't respond to a notification or request to talk, then we're sort of stuck where we are and we can't proceed. So I'm seeing 11%, 10% now of folks saying that it's fact, and most folks saying that it's fiction. So this one is fiction. Complaints proceed through the process mandated in the HPA, even if the investigated person is unresponsive. And the reason I have this slide and this question in here is just to let you know that being unresponsive can actually make things worse for the investigated person. So a good tip is to always respond and cooperate with the college on complaint matters. So complaint also proceeds through the process described in the HPA, even if the investigated person resigns from the job where the complaint occurred, or if they resign from the college itself, complaint's still going to proceed. So regulated members do have obligations under the HPA to respond to and cooperate with their college regarding investigator requests, like to interview them or to provide documentation. Regulated members are also obliged to comply with notices to attend. Primarily, this occurs hearings, and if you get a notice to attend a hearing, and also notices to produce. And primarily, this will involve producing documents related to a complaint matter. I'd also just want to touch on the obligations of the college as well, and how we respond to and interact with anyone involved with the complaints process. Our goal is always to continue to work hard at incorporating principles of trauma-informed services into all ACSLPA functions, and particularly for complaint matters as they involve sensitive information. What this looks like will vary on a case-by-case basis, and we are always learning and adapting our procedure. But our basic operating principle is that while the process is scary and it sort of has to be under the HPA, the people you interact with in the process don't have to be. So we're going to delve into regulated member obligations a little bit more. So it's important for regulated members to stay in contact with their college and to make sure their contact information is up to date. So another really good tip is always update your contact information on your ACSLPA profile whenever it changes. So when your employer changes, when your phone number changes, when your address changes, this is the information that we use to reach out if we ever need to contact you about complaint matters. And sometimes if we just can't reach a regulated member, we might start thinking they're being unresponsive. So it's also important to ensure that ACSLPA-wide communications reach you, like our monthly essentials email. This is where we inform members about new or updated practice guidance. And as regulated members must practice in compliance with the most current minimum standards, it's important to stay updated with them. And so this actually brings us to the end of my slides, and finished up. We ran out of slides before we ran out of time, so we'll give you some more time to sort of finish up your lunch. And I know many of you are going back straight back into work. Just to wrap up, one, it's important to know your minimum practice standards, because a breach of minimum standards may be considered unprofessional conduct, and these breaches are what lead to complaints. So it's important to know your minimum standards and always practice by them. However, if you are ever involved in a complaint matter, it's important to remember your rights as a regulated member. Really good tip is to be responsive and to cooperate. And also, really good tip from me is to think about legal counsel and also other supports. And this may be mental health support, or just making sure you have a support person in place. That might be just telling a loved one or a colleague about what's happening, and they can support you through it. Not that they would be providing advice or legal advice or anything, but I think it's just super important just to make sure you have mental health supports in place through it. As I mentioned, it could be very stressful and complex to navigate on your own. So we will wrap up there. I just want to thank everyone for joining us. I know September is a very busy month, and you all are joining. A lot of you are joining on your lunch break and coming straight out of practice and going straight back in. So happy to give you 10 more minutes to sort of settle before jumping back into work. And just also a quick thank you to ACSLPA staff who always support with the technical and operational pieces of these webinars as well. It's a bit different today, so just thanks to them for making everything go smoothly. And I've just popped my email in the chat. If anyone has questions, feel free to email me.